The decision whether to hire a guardian ad litem, sometimes called a GAL, can be one of the biggest strategic moves that you make in your case. In this video, we'll explain A, what a GAL is, B, how much one costs, C, the value of one, and D, why you might not want a GAL in your case. So what is a GAL? In a child custody case, a guardian ad litem, or GAL, is someone who investigates the party's parenting-related allegations and makes recommendations to the judge, such as recommending which party should have custody, which means primary care. The judge usually follows those recommendations. How much does one cost? The typical GAL in Snohomish County, Washington, where I practice, charges between $75 and $250 per hour and requires an advance fee deposit, or sometimes called a retainer, of $1,500 to around $3,500. The court normally apportions these fees between the parties 50-50, or based on the parties' proportionate incomes. Sometimes the court instead apportions all or nearly all the fees to the requesting party, especially when the court doubts a GAL would be of much benefit. The local government occasionally pays the associated fees, but that is very rare in my experience. If you're requesting a GAL, you should be prepared to pay out of your own pocket for the entirety of the cost. When does a GAL bring value to the proceeding? A court will ordinarily see value in appointing a GAL when two or more of the following factors are present in your case. The first would be allegations of abuse or addiction, including domestic violence, sexual abuse, drug abuse, alcoholism, abusive use of conflict, which means one parent habitually demeaning the other parent in front of the children or something similar to that. Or perhaps it means unreasonably withholding the children from the other parent. The GAL, unlike a judge, can go outside the courtroom and investigate these types of allegations. Another factor which may necessitate a GAL is if there is information which needs to be gained directly from the children in the case. The court usually will not want your children to testify in court, but the court may nonetheless want information from them. In that situation, the court often will want a GAL to tactfully interview the children and then report back on what the children said. A third factor that may necessitate the appointment of a GAL would be if there is information in the hands of CPS, or Child Protective Services. According to Washington law, a GAL can access certain CPS records that the parties cannot. A fourth reason for appointing a GAL would be if there are contradictory declarations from the parties. The greater the difference in the parties' parenting-related allegations, the more the court will want a GAL to investigate what's really going on. A fifth reason for wanting a GAL would be if there is inadmissible evidence that the court nonetheless wants to know about. A GAL, unlike the court, can usually review and consider inadmissible evidence such as hearsay, though the inadmissible evidence generally cannot be the sole basis for the GAL's recommendations to the court. A sixth factor that may necessitate a GAL would be if there is multimedia evidence in the case. The court often will not review multimedia evidence, such as videos and audio recordings, prior to trial. This is a practical issue. Watching videos and listening to recordings takes time, which the court has very little of at these hearings, as opposed to the time available at trial. A GAL, on the other hand, can review multimedia materials and report his or her opinions to the court. And a seventh and related reason for appointing a GAL would be if there are large amounts of evidence to be sorted through. Similar to multimedia evidence, the court's time constraints warrant a GAL when there are large volumes of evidence to review. Now let's talk about why you would not want a guardian ad litem in your case. One factor might be financial cost. As I just described, a GAL can be expensive, very expensive. Another reason you might not want a GAL is that they have less familiarity with the law and legal norms than, say, attorneys might or judges might. That means GALs sometimes misapply legal standards when making recommendations to the court. This can be especially frustrating to parties who are in the right but have a runaway GAL, so to speak. Appointing an attorney as GAL can minimize this risk, but attorney GALs charge more. Another reason you might not want a GAL is that they can be particularly influenced by personalities, perhaps more so than a judge would be. This is because GALs often formulate their opinions by informally interviewing parties and witnesses out of the courtroom. That means that if the other side has a very likable personality and you don't come across quite as likable, it could hurt you to have a GAL interview everyone. The GAL may favor the opposing party. A reason you might not want a GAL is that it may take attention away from the materials that have already been submitted to the court. GALs tend to pay more attention to the evidence that they have the unique ability to gather, as opposed to the evidence that's already been submitted to the court. This increases the probability of a GAL favoring the party who seemed to be more likable in his or her out-of-court interview, despite the evidence against that person. And the fifth reason you might not want a GAL is that he or she can be a true game changer. When the court appoints a GAL, all bets are off, so to speak. His or her recommendations tend to be difficult to predict and can dramatically change your case's dynamic. If you like the way the case has been going without a GAL, you probably do not want to risk bringing one on board. If you'd like more information, I'd encourage you to go to our website and click on the Resources tab. There you'll find a number of articles, guides, and videos on various legal topics. And here is the web address for our firm's resources page.